We were set back to the Gujarat government today when the Supreme Court asked the state its reasons to allow premature release of 11 life convicts in the rape and murder of Bilkis and her family members. A bench of Justice K.M. Joseph and V.V. Nagarathna also questioned the repeated paroles to the convicts in the case and asked whether the same privilege would be afforded to common people. In a scathing comment, the court said that the question is whether the government applied its mind and what material formed the basis of its decision. Today, it is Bilkis. Tomorrow, it can be you or me. The centre and Gujarat, meanwhile, will likely challenge a previous Supreme Court order that had sought from them the case files. Gujarat sought to not give the files, saying that there is privilege involved and that they will file a plea seeking a review of the court's order. The question, though, is that can the government in any way justify the relief, the repeated relief and parole given to these convicted criminals, and why do they seemingly continue to shield these men who stand convicted, not accused, convicted of crimes as heinous as that of rape and murder? And how do they answer the Supreme Court when it warns? Yesterday it was Bilkis, tomorrow it could be you or me.
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
We've actually got political analysts and lawyers on our panel today. Deshratan Nigam, lawyer; Naveen Chomal, also lawyer; Nikhil Jain, advocate; and political analyst Kapil Madan. I want to start with you, Deshratan Nigam. Why the secrecy? Why is the state not producing the files with reasons for giving remission and relief to the convicts in Bilkis's rape and the murder of her family members? Why are they so secretive? Or in the Supreme Court's words, what are they hiding?
I don't have that answer because they said they will file a review petition of the order, where they are saying that these reasons to be disclosed. Generally, ordinarily, a reason is supposed to be disclosed, because then you know how the mind has been applied and what the material has been taken. I believe they have also filed all the documents before the court, and that needs to be scrutinized, and I think the opposite side will file its response to the documents which have been filed.
No, actually they have not given the reason. That's why Justice Joseph said, if you don't give us a reason, we will draw our own conclusions. The question they asked was, has the government applied its mind, and what material formed the basis of its decision? That why did they have relief given to convicts who were required to be in jail for the rest of their natural life? The government hasn't given the Supreme Court reasons. And I'm asking why.
See, the fact is, the reasons can be borne out from the documents. It may not have been written down. It
would be borne out of the documents, and that conclusions can be drawn. However, generally ordinary, as I said, reasons are supposed to be given so that one can see the application of it. In this case, they are claiming privilege. Privilege on what ground is to be seen when the review petition will come out.
But does it not seem suspicious to you? Why are you continuously even citing privilege to not furnish documents that will answer a simple question? What did you find so outstanding in these men that you decided to give them remission?
See, let me tell you, I can only tell you about how the remission is given. Remission, there are two aspects of remission. One, the conviction and the undergone imprisonment. In this case, they have undergone mandatory imprisonment subject to the remission laws. So that punishment aspect is over. Here, whether they should be released or not is the second part. Its conviction and the imprisonment is over. Absolutely over. Mandatory imprisonment of life.
Sir, while you are saying this was done as a process of law, let's bring in Nikhil Jain, and correct me if I'm wrong, the Supreme Court today seemed to suggest that in saying the process of law has been applied is like comparing apples and oranges. You are talking about gang rape and mass murder and comparing it to an act of murder of an individual. Nikhil Jain.
So, Ms. Joshi, Ms. Nigam just said that they have served their sentences. I think he's a much senior lawyer than I am, but I think he's forgetting that the sentence for death causing death, and that to so many people at a time, is life sentence. As you mentioned in the start of your program, that these people were to serve imprisonment till the end of their life. What has been granted to them is something called as a remission, when in such cases, people who are imprisoned to a life imprisonment sentence can be released after they have served 14 years by either by the state government, by the appropriate government, right? That is done under section 432 of the CRPC. But instead of getting into the technicalities, I want the people who have not gone through the details of this case to understand what really happened. 28th February 2002, this woman comes to her family, her original house, her parents, her father's house, to celebrate Eid. A couple of days later, she has to flee her village and go to a tribal area and dress up as a tribal because she knows riots were going on and people were out to murder her. Several people, about 10-15 people, come in jeeps armed with weapons. They rape her, they kill her 3-year-old infant, they kill 6 other members of her family. They rape her mother, they leave her in that state thinking that she has already died. Hours later, she is alive and she goes back to the tribal area where she was hiding. She goes to the police station, she tries to lodge a complaint, she tells the police the ordeal that she has went through, and the policeman files a complaint that is not matching what the victim is saying. He files a false complaint, right? And he makes use of the fact that this is an illiterate woman who did not know what she was saying. She tells one thing to the police officer, he notes another thing. Then the medical examiner who examined her, he creates a false report. The entire ecosystem of the Gujarat state government at the time in 2002 tried to fudge away this case where a woman was raped, her mother was raped, an infant was killed, 6 other people were killed. The entire system was in this, and then the Supreme Court had to order the Central Bureau of Investigation to step in, do a fair investigation, and that was when all these facts were unearthed. The trial court convicted all these people. These 11 people are not all the people who were just murdering and raping the woman and her mother and a child and other people of her family. This also includes the police officer who was entrusted with the public state duty of protecting her, with the medical examiner who was sworn to the Hippocratic Oath. Right? These people included those 11 convicts.
Okay,
the trial court sentenced all of them to life.
First tried to protect the convicts,
the High Court
and now is giving them relief, Naveen Chomar. And the most chilling part is that the court has to say that if today it is Bilkis, tomorrow it can be somebody else.
I think I need to answer this question in all details for the benefit of our esteemed viewers also. Many of them are lawyers and high judges also. Please appreciate what has happened in this case.
Mr. Chomar, can we talk about today what the Supreme Court is saying? The Supreme Court today very simply is saying that give us the files.
Yes.
You don't have enough reasons to have given this kind of relief to these men. And public good must be kept in mind. Was public good kept in mind while giving remission to the criminals here, to the convicts?
No. Please appreciate, Padmaja ji, there are 2-3 aspects which the court dealt upon. Court basically went on an absolutely wrong premise, saying that this particular type of murder, like for example massacre, should not be compared with regular murders, and they said that you cannot compare apples with pears. So for the knowledge of the ignorant Supreme Court judge Mr. Joseph also, let me explain that as per the law, as per the rules of 1992 and all the other states also, for commuting the sentence, that is not 432 as my learned friend said, it is 433 of the CRPC, their sentence has been commuted. So in commuting the sentence, there are different categories. So whenever there is a life imprisonment, supposing the man commits a murder in the heat of the moment, for his self-defense, he is supposed to undergo 18 years. That is a category.
Okay.
Supposing a man
if the state government within its rights, sir, in granting remission, then why is it not putting that reasoning before the court?
Yes.
Why aren't they providing those files to the court?
No, see, I am not privy to those particular points of the state government. Let them file the petition, we all will come to know what their points are there. So I cannot speak on behalf of the government what is in their mind. So that is not the main issue.
But
Where
that is the main
judge
issue
went
according to
wrong
the
today
Supreme Court.
is that
They
he
are
started
saying,
believing-
hold on a second, sir.
Yes.
Here is what the court said today. These are a bunch of people that were convicted. First, you gave them repeated parole. Then you have given them remission, which is a form of relief. What was your reason for doing it? Was the principle of public good applied? The court is saying, we don't think that principle of public good has been applied. Give us your reasons. Now the state is saying, we will not give you reasons. Why?
That Padmaja ji shows the ignorance of the judge. He doesn't know the law. These remissions are given all over India to all convicts.
Okay,
So
Kapil Madan,
just because these people are Hindus,
it's the ignorance of the bench.
Now, the problem, Padmaja, is now the gentleman here, first I would like to take a strong objection. He is calling the Supreme Court ignorant. And perhaps to me, he looks, even more ignorant than anyone I have ever met. Now, what he is trying to say, what is the Supreme Court has said? Now, Supreme Court has said, you please give us the file so that we know as Supreme Court what weighed with the state while they decided to give this remission. They wanted to, find out the reasoning of the state. Now, this gentleman here who claims himself, a lawyer, he says that the Supreme Court is ignorant. And the Supreme Court does not know. That's the reason why they have sought. And the fact that the government is trying to withhold this information shows that there is something which they don't want the Supreme Court to see. That's the point. I mean, this is an example of, manifestation of repulsive politics. Forget for a minute, forget the laws, forget the technicalities. I mean, don't you think as a victim of this heinous crime is entitled to know why these accused, or in fact not the accused, these convicts were released?
Fair point. Withholding information makes it seem, Naveen Chomal, that the intentions were political rather than legal. Mr. Chomal.
we have to go by the laws. We have to go by the laws. The country is governed by the laws. When lakhs and lakhs of citizens who are inside the prisons have been given the remission following the very same principles, there have been Muslims also have got the same remission. So why are you denying because these people are Hindus? That is the question. Mr. Justice Joseph is getting into various controversies. He is about to retire. So he is passing all wrong orders one after another. That is the shocking thing.
Okay, has this principle, Nikhil Jain, been applied in other cases as well?
Ms. Joshi, Mr. Chomal is saying these same principles are applied to lakhs of citizens granted these remissions. I don't know how many lakhs of people have been granted remissions. Even if they are, what are the principles? This is exactly what the court is asking. On what principles was these remissions granted? And I'm sorry, but I think Mr. Chomal is in grave contempt of court. He's questioning the merits, the intention of a judge of the Supreme Court saying that he's about to retire in a case like this. And let me talk about what happened in the hearing today, right? First of all, it was the additional Solicitor General of India appearing for the state government as well as the central government. Why is it that? Why this shows this very appearance of a single lawyer for both the different distinct governments show that this is nothing but political. These people were released because it was the election time. They wanted to send out a message. And what the court is asking today is, why were they released? What were the grounds? What were the bases? What were the notings? What were the documents? One of these accused is a person who got a molestation FIR against him in 2020 while he was out in parole. And these people, this state government, this Gujarat government wants to let them out. On what principles was that done? What public good
the fact that there is secrecy, the fact that after their release, they were seen on a political platform with a BJP MLA and a BJP MP, doesn't that reinforce the suspicion that the reasons were more political than legal or humanitarian? Deshratan Nigam.
Yeah. I was coming to you because I've heard so many arguments being, flying across everybody's face. But I think the law on the subject is very clear that once there is a good behavior inside the jail, The first and foremost consideration is after the mandatory period of imprisonment has undergone, the first and foremost is the conduct and good behavior inside the jail.
Sir, again, these are settled principles, and while you and I are arguing about it on TV, isn't the government bound to also explain its reasoning in the Supreme Court? They are not telling the court is saying, okay, fine, were they well behaved? Tell us. Government is saying, we won't tell you.
See, that is what I am saying. Let us wait. Are they relying on some judgment of the court to claim that privilege? I am not sure, because ordinarily, as I began, the reasons are to be disclosed.
Okay, now, reasons are yet to be disclosed. Don't jump the gun, Nikhil Jain. Quickly, and you're trying to show something.
Mr. Nigam, I must point out to you 432 of the Criminal Code of Procedure, power to suspend or remit sentences. The appropriate government may. Mr. Nigam is repeatedly trying to present as if it was the right of these people to release. It was not their right. It was a discretion of the appropriate government, in this case being the state government. And when discretion is exercised by a government, it has to be on the principles of natural justice, on fairness, on logics. It cannot be arbitrary on the basis of some privileged information. What is the privileged information? I can't understand how can the Additional Solicitor General even make such an argument to go before the Supreme Court and say it is privileged why we remitted certain people. These people are those, when they are released, the BJP MLA says that they are Brahmins with good sanskar. Should we release all the Brahmins with good sanskar?
And also the principle of public good has to be applied, and the simple principle of natural justice, where if these people have the right to relief, the victim also has the right to know what were the grounds on which they have been given relief. Surely that,
Certainly not, because victim is out of the picture now. The conviction given, imprisonment gone. This is between the state and the person who have been convicted. Victim is nowhere in the picture. Please understand. Where does it say? Please show me under 432 or 433. Where does the name of victim comes into the picture?
Okay, very quickly, Nikhil Jain, respond to that.
Victim's opinion is not to be considered here.
Okay.
Not at all.
It is a writ petition filed by Bilkis Bano, the victim. It is a writ petition filed by Bilkis Bano, the victim. She is a party to the case. She has the right for it. She is a victim. I think we should not get into these technicalities of law, that where does 432 mention about a victim. I think the victim at the very least has the right to know why people who raped her, her mother, killed her infant, killed her family members were released. There is nothing wrong. She is a stakeholder in the crime that was committed upon her, and for her to ask why these people were released is nothing but justice being sought, justice that the court is trying to give, and Mr. Nigam wants that justice not to be served, because BJP's political ends need to be met without question in a privileged manner.
Well, in this case, in public good, in the interest of justice, at the very least, if there are people convicted of rape and murder who are let out, at least the victim and her family needs to know why. Can that be hidden behind the veil of privilege? I'm going to leave it to your judgment. Thanks very much, all gentlemen, for joining.